Hi, it's Tina and Tim. We're back with some more questions for all of you and answers, hopefully. So, Tina, today's question is, what is an initial appearance? And when looking at an original custody petition, what can be achieved in that appearance?
Okay. The original petition for custody, first off, all means that neither parent has an order of custody giving them parental rights of access. So at the initial appearance, either the court is going to set a temporary schedule based upon agreement. The court may take short testimony from the parties, or the court may adjourn, meaning postpone the matter for parents to get attorneys and assign an attorney for the child or children. And then you'll come back and either one, have an agreement as to a temporary schedule of parenting time, or the court will take testimony at that time. And then after a short bit of testimony, we'll render a decision about parents' custodial access pending a further determination by the court. And that just means the next court appearance, or it could be a final order after a trial. So just remember that. And the other thing people need to remember is that attorneys will not, if they're there at the initial appearance, have the ability to tell your entire story. The courts only allot maybe 15 minutes or so to get information necessary to move on. So just remember that an attorney has to selectively pick the most important things that they want to get across on your matter. So don't get upset at your lawyer because they couldn't tell the entire story, and the court will not let you, as a represented party, the opportunity to tell your story. It's not an appropriate time. There'll come a time, and your story means it's at a hearing or a trial. I hope that answers your question.